what I haven't said to Fran, I'm going to drop her in, is what I've done for each session is start by asking the adjunct if they can just give us a kind of Jersey-centric overview of the issues that we're going to go on to discuss. So what we're left with this afternoon is looking at the law relating to directors' duties. We've already discussed the liabilities of directors, particularly in the course of insolvency, looking at misfeasance and fraudulent and wrongful trading. We're moving on to look at directors' duties, which will take some time, and then on to minority protection, so unfair prejudice and getting windings up for what they're worth. Do you have any kind of broad overview of
I just thought I was going to listen. And I think probably what I would say is that thing about directors' duties, and as I think Ollie and Laurent, you really understand this. It's the thing that everybody just brushes over, in the sense that it is the thing that in board meetings it just becomes so formulaic, we disclose our interests and then that's fine. But when things then go wrong, and obviously for 99% of the transactions they never go wrong, that is when you're absolutely in the furnace. I mean, I have had clients who they basically were, it was a board and they just fell out with each other. It was just, there were basically 3 US promoters and some local meds, and they fell out with each other. And we spent, and this is a Tetragon case, so Deere, the Paddy Deere case, which you read, but ultimately, because they fell out, all the focus of the case was on whether or not they knew that each other was interested in the management business, which of course they did because they've been in business with each other for years, but we didn't set it out in the board minutes. And for you then to go through, and for all the directors to be in court for about 3 years going through, it's just absolute hell. All because the question is, should they spell out in the board minutes or not, all of their duties. The other area where this all comes into the furnace as well is where you find out that you have a transaction that doesn't work out, and then you have shareholders or creditors who are then saying, look, did you guys really think about this deal? Were you just there representing your shareholders? Were you just a stooge because you're representing the Guernsey administrator? How much did you know? Was the board, have appropriate skill and care? All of these massive litigation transactions, which we in the corporate side hang over to our litigation colleagues, they all come back to directors' duties. And it's great for the litigators, but if you're the one that drafted the minutes, this is what you need to hear government, because you're absolutely in the finance on them.
And there's a huge volume of law ultimately in comparison to the other topics that we've looked at. There's a volume of law going to directors' duties, because once you've identified what those core duties are, fairly simple, each one then, certainly in the English jurisprudence, has a body of case law to go with it. Now, the law relating to directors' duties in Guernsey has obviously gone through some interesting recent developments, with the decision of the court in Carlisle taking the opportunity to quite comprehensively cover off the core duties that are owed in Guernsey law, to a degree moving away from the application of those duties in the English jurisprudence, but still it's kept relatively close, but the formulation it does differ. And seeking to draw a fairly clear distinction between fiduciary duties and the other duties that a director may owe, which in fact is clearer in the Carlisle judgment than I would say is the case in any of the English jurisprudence, where the courts just have kind of moved away from focusing too much on what is a fiduciary duty and what's not, and just looking at the application of the duties in general, on the basis that the breach of any of those duties has the same end result, which, if proven, is some remedy to the company, irrespective of whether it was a fiduciary duty or not. But the Carlisle case then of all the ones that we've talked about, is probably one of the most useful ones to read at this stage. I'm aware that an appeal is pending. It's not been determined, or
it's not been determined. We expected the judgment back in November.
Yeah.
It's still out there. I mean, I think I would be surprised if, I mean, I know nothing about this, but I would be surprised if the summary of the director's duties would actually change as a result of the appeal. But I think it's probably just something just to keep an eye out for, because, you know, ultimately so much money was lost on Carlisle. It may be that the Court of Appeal has something to say about it, but we just don't know.
I think you're right. The way in which the court set out the director's duties as they exist in Guernsey law was clear, straightforward. We'll come on to it in a moment, but I thought it was really quite well formulated. And something akin to the now statutory duties that exist under the 2006 Act in England and Wales. So you're right, I imagine, the appeal is going to go to the substance, isn't it? Without having any wider impact on the way those duties were framed, save that the Court of Appeal may have some other view on that makeup, but I think it's unlikely. Now, you're going to have a better feel than I do for the facts and the nature of Carlisle's business. But my understanding is it's borrowing money to buy up mortgage securities, and it's holding a portfolio of these securities. And those securities obviously have a value. You go forward in time and Carlisle enters insolvency. And the allegations made by the liquidators was that the directors ought to have sold the portfolio held by Carlisle, either in full or in part, at a time when it had a better value prior to economic downturn. And that was the context in which the court was asked to consider the various issues of breach of duty, etc., that were brought against the directors. Ultimately, the claim was dismissed and no breaches of duty are found, hence presumably the pending appeal. But the court takes the opportunity to go through and recast directors' duties in Guernsey law. In SPL, before we look onto those duties in detail, in SPL you see here the commentary. In the absence of any express provision or settled jurisprudence in Guernsey law, regard can properly be had to English law for guidance. So your fallback position on the interpretation of the duties as set out in Carlisle is going to be with regard to the English jurisprudence, look back to the English case law. And so hence I've incorporated the relevant cases for the Carlisle duties in these slides. But remember a point I made earlier, which is your starting point has always got to be the Guernsey law. And you're only, of course, looking back to English law for interpretation. So in terms of what I'll be looking for, I'll be looking for the reference to SPL in addition to Carlisle, just to justify why, in terms of interpreting some of those duties, you may be looking back to the English case law. Now, I think almost exclusively we'll take the duties in Carlisle and then go to the UK law to aid interpretation. The only exception to that is the general principle as to whom these duties are owed. The reason why in Carlisle, the reason being that in Carlisle, the court looked back to the position in England and Wales, which was set out in Percival and Wright back in 1982, and they simply affirmed that principle. So they took the starting point in Percival and Wright that the director's duties are owed to the company as a whole and not to individual shareholders, and affirmed that was the position in Guernsey. From there then, the court in Carlisle looked to distinguish, as I said a few moments ago, between fiduciary duties owed by directors, which are obviously subject to a higher level of, to a higher standard, and those general duties of care and skill. In Extrasure, the court was asked to reflect on what fiduciary duties actually meant and explain that it concerns a higher standard of honesty and loyalty as opposed to competence. Fiduciary duty is concerned with honesty and loyalty as opposed to competence. Hence why the distinction in Carlisle fits within the general jurisprudence from Extrasure. So fiduciary duties are higher standard, honesty and loyalty, as opposed to competence. Those are dealt with in the general duties of care and skill. That distinction, as I said, the English courts have tended to move away from because, frankly, it doesn't make any significant difference insofar as the outcome is concerned. The remedy, the company has suffered loss, and the remedy is the same, whether the duty which has been breached is fiduciary or not. You're simply looking to the standard by which the individual is judged. The reason why that becomes less important is because each of the duties in the 2006 Act, for the most part, are quite clear in the standard which is being applied. Here, though, 5 bullets. The headline duties that the court defined in Carlisle, all of which are subject in that first line to the core fiduciary duty of loyalty. I'll move on to look at each of those in turn, but generally, if you were looking to plead a claim for breach of duty, what you would find is that you may have some specific duty which has been breached. For example, the duty to avoid conflicts of interest. That will only arise in certain circumstances on certain facts. But beyond that, you have the slightly more general duties, which probably, if you can show a breach of the duty to avoid conflicts of interest, you can probably establish, by reason of that breach, there's been a duty to, I don't know, act in the best interest of the company. That's certainly how we tend to frame it in our pleadings in England and Wales, is you've got these general duties, and if you're alleging a breach of a specific duty, it probably falls in that you've breached the other duties as well. The more mud that we can throw, the more it's likely to stick. So have that in mind with your overarching duty of loyalty. If you can evidence some other breach, the likelihood is that in itself goes to demonstrating a breach of the overarching duty of loyalty. And then you can see a director must act in what he honestly considers to be the best interest of the company. The court develops that further. The central reason for the actions being taken by a director must be the best interest of the company. However, a director's action is not wrong because incidentally it happens to benefit someone else. We'll come back to look at that in a bit more detail. The director must exercise independent judgment, must oversee the company and keep himself sufficiently informed to make his own decisions. That's then where you can see some interplay with the issues we discussed earlier with regard to shadow directors. Probably the duty that I think I tend to come across possibly most often in practice is the duty to avoid conflicts of interest, and the fact that a conflict of interest can arise in so many different circumstances. As we can see, the framing of that is often incredibly broad. Because it just has to necessarily cover so many different practical types of conflict that might arise in practice. And a director must act for the proper purposes of the company and may be in breach of the duty for a failure to exercise powers in accordance with the company's constitution, which again ties back to our discussions this morning. The fact that a transaction will be saved, a third party will be protected under the law if that transaction is entered into pursuant to some excess of power, whether within the objects of the company or whether within the powers of the director specifically. That doesn't mean that the director himself avoids liability. And we saw that that was specifically carved out in the relevant sections of the law, and also here it feeds into the customary law statement of what directors' duties entail. So we'll look through those one by one. It was earlier then that we also discussed the interesting tension between objective and subjective tests when judging the standard by which someone should be held, and Carlyle here then is different. The standard of care to which a director will be held is that of the reasonable person. And so the court frames it as an objective test. However, it then introduces the subjective element, that reasonable person having both the director's own knowledge, skill, and experience, and also the knowledge, skill, and experience that may be reasonably expected of someone with the same function of that director. That isn't surprising. That is exactly the same approach taken by the English courts. You create an overarching objective test, but in fact, you then introduce these subjective elements. So that in fact, what the court is considering is quite simply all the circumstances. And it ought not give rise to any issue in practice. You're simply assessing the conduct of the director by reference to both standards. And I think it probably helps to look at them in effect as separate standards. Where is he on the subjective standard, looking to his own knowledge, skill, and experience? And where is he on the objective standard, looking to the knowledge, skill, and experience of the reasonable person? I think that's something you have to be settled with. Lauren gave us a nice analogy earlier, didn't you? A pastry with an outer shell but a soft subjective middle, and that's quite
better for lunch.
That's quite right. And I know this is something when I'm teaching undergraduate students, they just can't wrap their head around. How can you have objective and subjective standards? As I said, we treat them as two different things. The court is looking at all the circumstances. Helpfully, though, and unlike the English law, the court in Carlisle went on to give us some further guiding factors as to elements to which the court should have regard when considering the standard of diligence and skill professed by a particular director. And this is interesting because the English courts don't go down this line at all. In effect, the jurisprudence dealing with the standards to which the director will be subject pretty much stops with the previous slide. It doesn't give us much further information as to what the courts will actually have regard to. While here in Carlisle, we're given quite a firm steer. It's not an exhaustive list. The court was very clear in its wording. The following factors can be used, must be used. It wasn't, I don't think, intended to be exhaustive. But these are some of the factors to which you can have regard. The role of the director, himself or herself, in the governance and management structure of the company, which seems to imply the court may perhaps have sympathy as between the different levels to which a director may be involved within governance and management. That could imply, I'm not saying it does, but it could imply that a managing director might be held to a higher standard as having overall involvement and responsibility for governance and management than perhaps a marketing director, whose function is limited to one very specific role. I don't know, because the court didn't advance, but that's what I would tend to read into that, is that the court is drawing some distinction, or at least recognising the different levels at which even directors can operate within governance and management. The skill which the director has held himself or herself out as having, so the higher the level of skill professed by the individual, the higher the standard to which they will be held. Finance director then, who holds himself out as having certain qualifications and expertise, will probably be held to that level as opposed to any lower level. It's the bar they've set for themselves, if you like. It's an interesting one, the level of remuneration of the director, which I find as an odd conclusion, but never mind. Again, the court doesn't give us a huge amount of guidance as to what that's intended to mean, but if you were to just look at that academically, does that mean the higher the level of remuneration, the higher the standard the individual will be held to? It's a factor that the court said should be held to. And the size of the company and the nature of the business. Again, no real indication as to what's intended by that, but possibly the more complex, the larger the size of the operation, the higher the standard the director will be subject to. From a policy perspective, that's probably right, because certainly in England and Wales, and this doesn't qualify here, but you've got, I can't remember what the statistics are, but something like 90% of companies are small, privately held companies with director shareholders. They are the business. And much of the 2006 reforms were designed to make it easier for them to do business through the medium of the company. And so the courts are sympathetic to the fact that the majority of directors in the UK aren't professional directors. This isn't their profession, this isn't their role. They're actually mechanics or cafe owners or whatever. And so the court is sympathetic to that. Whether or not that's what's intended here, I don't know. But when I think about size of company, that's what immediately springs to mind.
Sorry, just to interrupt, I probably would agree with that again, because typically with these kinds of companies like Carlyle, actually the representatives from the manager would likely not receive a director's fee. Their overall remuneration comes from their participation as managers of the Carlyle Group. So it would be the local expertise, the local directors who would be receiving fee.
Yes.
So actually that would be more than possibly their fellow board directors. But I'm assuming here what the Lieutenant Bailiff was talking about was more an English principle, you know, because most of our directors are professional.
Yes,
but so I think she was kind of looking beyond the Carlyle case when she was saying that. It would be my guess. And
certainly then you look into the overlap with licensing and the regulatory laws. Again, this isn't a mechanic. This is something highly specialised, highly technical finance fund here, who's subject to all those licensing requirements, etc. as well. And so probably you'd expect to be more sophisticated and held to that higher standard. But we're kind of reading between the lines here. If you look to the judgment, they didn't give a huge amount of detail. I've only mentioned those two English cases just for the sake of completeness, because actually the principles set up by the Core and Carlyle extend, as I said a few moments ago, beyond the English principles. The decision in Re Jan of London basically brings in line, falls in line with this commentary here from Carlyle, where the English courts were looking to the same objective, subjective test for determining standards of care and skill. So that's the relevance of Re Jan, and the wording of the court is almost identical to what was used in Carlyle. I don't think that's because the court had regard to that case in Carlyle, but because that wording also then followed through to the 2006 Act.
Also New Jersey.
Yeah, absolutely. It's just that standard wording that's been jumped upon, albeit it doesn't sit that nicely, but it is what it is. Landhurst leasing is interesting. The court there says that it's no offence to say that a director was unaware of some issue, some conduct carried on by his fellow directors, because the the position of the director is such that he ought to be involving himself in all aspects of the company's governance and management. And so Reland has, it's no defence to plead ignorance of something that's been carried on. And I've seen practical examples of that recently, where wife was a director alongside husband, who was really the leading force in a leisure group, and really she was only appointed director for the tax boon that comes with her being a director shareholder, but taking his profits through her in effect, and she was stuck in a set of proceedings as he was, because she couldn't put her hands up and say, well, actually, I didn't know what was going on. The court will simply say, well, you ought to have known. So that was a bit unfortunate. You can follow through then to the various specific duties that the court identified. The duty to act honestly in the best interests of the company. Again, no difference to the position under the English common law. Here, Rees Smith and Fawcett. The wording slightly different. The directors must exercise their discretion bona fide in what they consider as the interests of the company. But I think that's equivalent, isn't it, to what you honestly consider to be the best interests of the company. In that first case there, Carlin and Drury, this is going way back, 1812, the court was considering how they determine what the best interests of the company are. And at that point in time in Carlin, the court's view that it was that it was simply a determination to be made by reference to the director's own thought process. It's simply a matter to be determined by reference to what they thought, in good faith, was the best outcome for the company. And the court took the opportunity there in Carlin to say pretty early on, the point that I made earlier, the court isn't interested in involving itself with the day-to-day management of a company. It just isn't interested in internal issues. And that policy, as we've seen this morning, has persisted for 200 years now. The court doesn't want to get involved in internal matters, and it will be sympathetic to the own good faith judgments of directors. That doesn't, though, do away with the objective standard. So when assessing what's bona fide in the best interest of the company, we then look to Charterbridge and Regent Crest. Under the English law, these both underpin what's now a statutory duty on equivalent terms to Rees Smith and Fawcett. I don't know why I put them that way around, but I did. Actually look to Charterbridge first. Charterbridge 1970 sets out a clearly objective test, determining whether the duty to act in the best interest of the company has been discharged must be determined by reference to whether the intelligent and honest man in the position of director could have reasonably believed that the transaction would be for the benefit of the company. So a purely objective test, no subjective consideration. Here, Charterbridge, the court is looking simply to judge the decision-making process of the director by the standard of the intelligent and honest man in the position of director.
Doesn't it also want to say that the decision that could have reasonably been made by the
in practical terms, yeah, within the confines of the company, but it doesn't go into what it then develops in Regent Crest, which is actually going back to the position as it was really in Carlin. The question is what the director honestly believed himself, irrespective of the confines of the company, and what it could or couldn't do. And quite simply, what did the director honestly believe to be in the best interest of the company? The issue therefore relates to the director's state of mind. That couldn't be a more subjective test if it tried. And so the approach then that you see the English courts taking now that we're under the 2006 Act, the statutory formulation of directors' duties, is that you're applying both objective and subjective tests to determine what is in the best interest of the company. And I think that's right. It covers off both bases, and it just has to be looked at as, well, first we judge by one standard, we then judge by the other, and we just look where we come out and take a view overall. The problem is that there's no real body of case law that's developed since to lead us down a path of, we can clearly see how the court is applying these principles, because it just hasn't developed. The courts haven't had the opportunity to take that forward, and I don't really know why, save that every case I've ever been involved in concerning directors' duties has been settled. We've issued them, but they've all been settled. So maybe that's a position across the board. Any other thoughts?
Not really. I mean, I suppose, I suppose when I am advising boards, you are very conscious of the fact that, this isn't that they have to get to the right answer, whether to do a deal or not. This is all about, and I think the other thing is, it's not being overly fixated on the process as well. But this, I think what I'm always trying to explain is that, what the court is looking to do is, it is to consider your thought process, and that you were properly taking into account things, and that you are acting in the best interest of the company. And it is perfectly possible that you can then come to what turns out in hindsight to be a really bad decision. But it's what you were thinking at the time, and therefore that's what brings the focus, I think, back on to minutes, which can be helpful evidence as to how you document, what the board were taking into account and how they're acting in the best interests.
Yeah.
There's a lot more focus now because of these big litigation cases that we're seeing, as to how this process is documented.
Absolutely. And in fact, that point on minuting then comes in when it comes to conflicts of interest, because although this has a very broad application, one of the most common instances I've seen it is, and we'll come on to look at it in a bit more detail in a moment, is where the directors have taken advantage of what the law defines as a corporate opportunity, some investment opportunity or similar, which is offered to the company, but which the directors then take for themselves. Now, that is a conflict. It falls within the overarching principle of the duty to avoid conflicts of interest. And in certain circumstances, it's permissible, but the English jurisprudence has developed such that it will only be permissible where that offer has been presented to the company. That opportunity has been presented to the company, and it's been genuinely rejected for some reason. And so again, hence the best evidence you can have is a set of minutes that say we put this opportunity to the board, and it was rejected because, and typically it would be for financial reasons. And that's one of the cases we'll come on to look at. But again, it's so important just to have that on paper, as to go against the argument that a minority shareholder then may subsequently bring to say, like, this was a good investment, this was a good opportunity, and somehow it's ended up with two of the directors running it for themselves through a SPV and taking all the profits. Those profits ought to have been ours. So I've seen that in practice on a couple of occasions. The general duty, though, to avoid conflicts of interest is set out in Carlisle in a similar way in which it is to the English law, in that it's a very broad formulation, because the way in which a potential conflict of interest could arise on a series of given facts could just be so fact-specific, based on the nature of the company, based on the nature of those involved. It necessarily has to be very, very broad. And so you see that a director must avoid actual or possible conflicts of interest, as between the company's interests and the director's personal interests, as well as avoiding conflicts between the duties owed to different principles of the company. It's a very wide formulation, but it's probably not gone so far as the English position, which you see there, Regal Hastings, and this is then copied through into the 2006 Act. a director of a company must avoid a situation in which he has or can have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. It is as broad as it could possibly be, subject to those various variables, direct or indirect. Conflicts may or possibly may conflict, has or can have. We're not talking about avoiding actual conflicts of interest alone. We are talking about avoiding possible potential conflicts of interest. In practice, that then means that any director who even verges on the possibility of being exposed to a conflict needs to declare it and go through the various procedural steps that we'll look onto in a short while to make sure that it cannot later be criticised for acting in breach of that duty. So there's no exhaustive list of the different ways in which conflicts of interest may arise. I've set out here probably the most common examples: corporate opportunity, competing directorships, and then whether Guernsey law really bills transactions involving self-interest, or I refer to it as self-dealing, where the director is causing the company to enter into some transaction on which he has an interest on the other side. Now, historically, the case law on that had been a complete prohibition. You cannot do that. But out of commercial necessity, that position had to be moderated. And so now you see in the legislation across Guernsey and Jersey and also in the UK, quite involved procedures for dealing with self-dealing, because commercially it happens. It's not by any means uncommon. So you can take conflicts of interest and broadly distill them into those three categories, but that's not to say that there aren't any other number of ways in which a conflict could potentially arise. But I just think it's useful to have a bit of a steer as to precisely what we're talking about in practice, given how broad these definitions are as to the duty. Corporate opportunity then, right? This isn't anything new. Going back to Cook and Deeks. Cook and Deeks is a great case from the English jurisprudence, because if you're ever stuck from authority, you can basically sell it to Cook and Deeks and you'll probably get a mark for it. It covered off so many different aspects of the company law, but at its heart, it was an issue. It was a case dealing with conflicts. And long story short, it concerns 4 directors of a company who divert railway construction contracts for their own benefit. They take them from the company. Those contracts were offered to the company. They take them for themselves. They run them themselves, and they enjoy the profits that those contracts make. There's a better example, which I'll set out in a bit more detail in Paso Silver Mines. But in Cook and Deeks, you see for the first time the court recognising that opportunity, that offer to invest in certain contracts and to make a profit, to run those contracts for profitable purposes, was an asset. That was an asset that belonged to the company to which it was offered. And for that reason, it would be treated like any other asset of the company. It belongs to that legal person, it belongs to that company, and it must not be misappropriated by the company's directors. In Prentice then, the court went on to recognise that the misappropriation of such an asset, there they talk about economic opportunities, but it's terminology for terminology's sake, it's no different to the idea of a corporate opportunity. The court in Prentice identified that would be a breach of fiduciary duty, so going to the very highest standards expected of a director. That would be a breach of your duty of good faith, your duty of loyalty, to take an asset presented to a company in this form and abstract it for yourself. It was in Paso, though, that the court realised that there had to be, or recognised that there had to be some moderation of this principle. It couldn't be as strict as it was set out in Cook and Deeks, because Cook and Deeks basically suggested that there could be no appropriation of this asset in any circumstances. It was an asset of the company, irrespective of whether or not it was taken up by the company. Misappropriation of it, taking it for a director's benefit, would be a breach of duty. In PASO, the principle is moderated slightly. In PASO, you've got an opportunity to purchase mining rights, certain plots of land. Those opportunities are put to the board of the company. And it's determined that the cost of purchasing those mining rights, notwithstanding the potential profits to be made, the cost of purchasing those mining rights was simply not viable. In fact, I think if you look at the facts, it would possibly have pushed the company into insolvency. It simply could not afford to purchase these mining rights. It could not take advantage of that opportunity. So what happens is two of the directors of the company, one of the company's employees, a geologist, another party, they form their own joint venture and they acquire the mining rights themselves through that JV. They obviously begin working the mines or whatever, exploring those mining rights. It gets to the point where they're beginning to generate profit, by which point in time, PASO's been taken over, the company's been taken over. And the new board who come in look back over all of this and take the view that it's a straightforward breach of duty based on Cook and Deeks. On that basis, the claim was for profits, an account of the profits that had been made, and more so, and I thought this was quite good, more so, a determination that the directors who had now got the interest in the JV held those on trust for company number one. And so I quite like that. But there we go. You can see where they're coming from. This is a misappropriation of an asset, and if we were talking about a physical asset, you would probably see the imposition of a constructive trust in respect of that asset. Long story short, the court determines that the claim must fail because the company was given the opportunity. It was presented with the opportunity at board level, and the decision was made not to take advantage of it. The decision was made bona fide. It was made in good faith. It was made honestly based on the financial position of the company at that point in time. The company simply couldn't take advantage of the opportunity, and so, as far as the court was concerned, that was the end of the matter. And anybody who could then seek themselves to take advantage of that opportunity would seek to do so. So there the court looked to the decision of the board being made in good faith and sound commercial reasons. The principle then in Cook and Deeks being moderated somewhat. And the English courts are now looking to, well, what was the decision-making process in circumstances where the opportunity was actually put to the company in the first instance. If it was rejected for sound commercial reasons, and that decision was made in good faith, then there's unlikely to be any breach of duty.
There was not, in that case, there was not like a declaration made contemporaneously by the two interested directors or any subsequent.
But they didn't yet reverse it or anything, so it wasn't
No,
later.
yeah, I'm asking them.
Do you mean in terms of disclosure?
I mean,
Did they disclose their interest before that?
the argument, or did they just look at
I don't know, to be honest with you. The point is, it wasn't, I don't think, relevant on the facts because that wasn't what the court went to. So in the report is, In the reports I've seen, there's no mention of whether disclosure was made or not at a subsequent stage.
Because to harvest that opportunity, which arose as a function of your office.
Yeah.
You know, a lawyer would probably be under a different, I mean, I think we'd be a bit worried about something.
Your best practice would absolutely be to
right.
disclose it in the usual way. The only hesitation I have is, well, one, I've never seen any reference to it. Number two, 1966, we didn't have the same statutory framework for making disclosures. What was I going to say? And the principle on which the court made its determination simply went to the catalyst for all of this, which was that the company rejected the opportunity. And so arguably it shouldn't make any difference whether there's a subsequent disclosure or not. The fact is, once the opportunity is rejected on for reasons of good faith and sound commercial reasons, whatever, it's anyone's game. It's gone, it's anyone's game. But I take your point, and absolutely the best practice would still be to go ahead and disclose at a later stage to avoid any issues. Now, that's all obviously hugely English-centric, but that's because, as far as I'm aware, I couldn't find any Guernsey cases dealing with the same issues. But it's something I've seen in practice.
I think in Guernsey, I mean, we are on the edge all the time, practically, with these kinds of decisions, because we have so many vehicles where a major shareholder will want to take a position on the board of directors, and so you have a director there who's representing a shareholder. At Carlisle, you there have the promoter or the manager of the vehicle putting its directors onto the board of the fund. That's perfectly normal practice, and a lot of people like that, so they seem to have skin in the game, bring the expertise. Or the alternative is that you completely stay out of that and run it as a separate vehicle. We will have directors who are on two boards seeking, with companies pursuing the same opportunities. And I guess how what we'll come on to next is how, as a lawyer, you will work through and find, a way of trying to protect those directors, because certainly with financial services here, it's, these issues absolutely come into the spotlight.
So we'll come on to the kind of statutory framework for making disclosures and what have you in a moment, but just exploring again common scenarios in which we might see conflict of interest. Competing directorships. The only reason I mentioned London and Mashonaland Co. is because historically the principle in English law is that there'd be no breach of duty if a director held competing directorships. The court came to that decision. I'm not entirely sure why, but I think that was very much at a time when the policy was to encourage the use of companies to foster economic growth. And the court saw no problem with a director holding directorships in competing companies, despite the fact that it was effectively playing one off against the other. Nevertheless, that took some time in English law to be resolved. It's now prohibited. And under, you see that, the relevant section of the Companies Act, any reference in this section to conflict of interest includes a conflict of interest and duty and a conflict of duties. So the English law has finally moved beyond Mashonaland. You're now prohibited from holding directorships in competing companies, subject to the disclosure framework. The only other point that I suppose feeds into that to an extent is evidenced in Coleman, which concerned the steps that a director may take while still a director of business A when he's looking to move into business B, which might be his own venture or some alternative competing venture. The courts weren't willing to conclude that the nature of the duties a director's owe is such that he must get to the end and terminate directorship A before he's allowed to do anything concerning B. and so allowed a director to take preliminary steps towards his transition into some alternative directorship, providing that he didn't do anything which constituted actual competition with directorship A. So the court's got some sympathy. It recognises you can't be expected to come to a complete end. You can't be expected to cease acting in one directorship before you move into something else. There has to be some fluidity. And so you can take steps in the latter stages of directorship A. You can take steps, preliminary steps, to set up your new business or to move into directorship B. You take preliminary steps, providing that you don't actively compete whilst you're the director of directorship A. There isn't a huge amount of meat on the bones as far as competing directorships are concerned, so it's not likely something I'd be likely to explore from an assessment point of view, because there's a better focus, more worthwhile discussion that comes from corporate opportunity and particularly transactions involving self-interest. But I flagged up competing directorships because, again, it's something you might tend to see as a practical conflict in reality. Transactions involving self-interest then, concerning the situation where a director is obviously the director of a company and he's involved, or the company is involved in entering into some transaction on which he has an interest on the other side. Now, the common law absolutely prohibited this. So Aberdeen Railway Co. And Blakey Bros. You've got John Blakey, who's a director of Aberdeen Railway Co., which is a railway, fitting out carriages and railway sidings, etc. And Blakey Bros., which John Blakey's a partner of, which supplies ironmongery and products, but in particular supplies iron chairs for use in carriages and on railway platforms, etc. Aberdeen Railway Co. needs a supply of iron chairs. Blakey Bros. Is happy to supply them. But on both sides of that transaction, you've got John Blakey. He's a director of Aberdeen Railway Co. And in that role, he's looking to get the iron chairs for the cheapest possible price. On the other side of the transaction, you've got John Blakey as a partner in Blakey Bros., who's looking to maximize his returns on the contract and thereby charge the highest possible price for the iron chairs. The court was quite blunt in its determination. No one with fiduciary duties to discharge shall be allowed to enter into engagements in which he has or can have a personal interest, conflicts with those who he is bound to protect. So no one owing fiduciary duties shall be allowed to enter into engagements which he has or can have a personal interest which conflicts with the interests of those who he is bound to protect. So a clear prohibition. You cannot, as a director, engage in self-dealing. That principle, though, as clear as it was formulated in Blakey Bros., and also as clear as the policy is from Blakey Bros., doesn't work in practice. That case is a good example because you can see Railway Co. is looking to pay the lowest possible price. Blakey Bros. Is looking to charge that highest possible price. But that's very black and white. Of course, directors can be placed in circumstances from time to time where it's gonna not be quite so clear that a conflict's arisen. And in any event, is it necessarily wrong for the director to be on both sides of the transaction? There was no give in the judgment in Blakey Bros. It was a categoric prohibition. You cannot do this. And across the jurisdictions, then that position has been moderated over time. And we're looking here then to Section 162 of the 2008 law and a few other provisions that we'll work through. And ultimately, the focus of all of this comes down to disclosure. But don't lose sight of the starting point under subsection 1, which is if the relevant transaction, under 2. Under subsection 1 is the disclosure obligation. Director of the company must immediately after becoming aware of the factors interested in the transaction or proposed transaction disclose the nature and extent of his interest. Don't lose sight of subsection 2, which says that no disclosure needs to be made if the transaction is on the company's usual terms and conditions that's being entered into in the ordinary course of business. That might actually catch a significant number of circumstances in which there could otherwise be criticism of self-dealing. If the basis of the transaction or the proposed transaction is on the company's usual terms and conditions, and if it's in the ordinary course of business, then no disclosure needs to be made. Subsection 3 looks to the nature of the disclosure. But it's subsection 4, which is slightly more interesting, which is, again, as we've seen from time to time, a saving provision, which confirms that notwithstanding that there's been a failure to comply with the disclosure provisions, the validity of the underlying transaction won't be affected by the lack of disclosure, by the failure of the director to abide by his duties under 162 subsection 1. So the transaction remains valid, but again, you then look to what the alternative remedies are, which we'll work through in a moment. Fran, did you mention Jackson and Deere earlier? I think you did. Did you say you acted on them?
The firm I was in at the time did.
Right.
I mean, I think there, as I recall reading the judgment, I think one of the issues there was, the reducing evidence of the extent to which what the board commonly knew, because they worked together over a number of years in terms of interest, needed to be actually minuted. And I think ultimately, evidence was adduced to the fact that, it was common, or it was the nature of the interests were understood, and therefore had been disclosed to the board. There was nothing that was being concealed. But, obviously the practical point is the extent to which one makes sure that that knowledge of interest is properly minuted. And the problem is with clients, they don't want to be minuting their interests at every quarterly board meeting, because you're not going to get on with the business of the meeting. So I think typically what would happen is that when you set up a company or a fund, you will have your disclosures. You will keep those with the company minutes, and anything new you then kind of top up. So if you take on a new directorship, you will immediately disclose that to the board. Obviously, as a practical matter, I think what I would say is, I was a director, notwithstanding the fact that said I'm interested or I have a directorship in company B. If it is relevant to the discussion of the meetings, you would naturally make that very clear and minute it as well. But I think it was an interesting case about the extent to which one should or ought to make very clear knowledge in terms of minutes.
Well, it was interesting. You had 6 directors, 2 of which were interested in the transaction. I'm not going to go into the detail, I'm not sure if I fully understood what was going on, but they were interested in whatever this structure was. So that's 2 of 6 who are potentially in conflict with Sardine. And as Fran said, that's known, it's disclosed, there's no element of concealment here. Ultimately, the transaction that was entered into was approved by 5 members of the board, with 1 dissenting. And it's he who then takes issue with all of this. So you've got the dissenting director, you've got the 2 who are conflicted, and then I can do the maths, you've got 3 left. And it's those 3 who the court focused their attention on. And the court focused on those as being, they grouped them as the independent directors in the judgment. And the court was satisfied that those 3 had properly exercised their duties, that they hadn't themselves acted in conflict, because they were experienced professional men, which, as we said earlier, is more often than not going to be the case given the nature of the work that's on the island. So they're experienced professional men. Not only that, they'd sworn affidavits to confirm their knowledge of the conflicts at the time the transaction was voted on. And the real kicker, I think, to properly safeguard your position, they'd taken independent legal advice on the nature of the transaction, the nature of the conflicts. With all of those factors in mind, there was no breach of duty. They hadn't in any way committed any form of wrongdoing, and the court gives quite a clear work through of why it comes to those conclusions. But it's looking predominantly to the point that they were experienced professional men. They were aware of the conflicts. They'd taken independent legal advice, and still they were satisfied that the transaction was, fit and proper for the company to enter into. Another point came from Jackson, which we'll look at after we've had a break in a while, but insofar as derivative claims are concerned, in Jackson, as something of an aside, the court recognised that the principle of the double derivative claim stands in Guernsey, which is actually going slightly further than how it's developed in England and Wales, and it's certainly further than it's developed as a principle in Jersey, i.e. a shareholder in a parent co can bring a derivative claim in respect of issues in a subsidiary, going over a layer, over an upper level, it's not up, is it, but working through the corporate structure in order to pursue a derivative claim. So a shareholder in a parent co can pursue a derivative claim in respect of issues going to conduct in a subsidiary. But I'll come back to that later on. Let's flag it out whilst we've got Jackson in front of us, which is interesting because, as I said, it goes beyond certainly the Jersey law and also really where the English law stands on those types of claims. I had one recently and we were a bit unsure whether or not we should run it or not, but we did. That, though, with some digression, is the basic position under 162 subsection 1 with regards disclosures. Immediately after becoming aware of a conflict or a potential conflict in respect of some transaction, it must be disclosed to the board, save that in subsection 2 as a carve out if the transaction is on the company's standard terms of business and it's in the ordinary course of its business. But the law doesn't stop there, it goes on a bit further. And in 167 subsection 1, you see a list of the circumstances in which a director might be interested in a transaction for purposes of section 162. So you need to start reading these together and make sure that you've got that clear in your mind, that they all work together in order to determine the circumstances in which that disclosure needs to be made. So assuming that the director isn't dealing on the standard terms and conditions of the company, and assuming it's not in the ordinary course of business, we then look to this list of various different types of transaction. And it's really rather wide, so I think it's going to catch pretty much everything. Director is a party to, or may derive a material benefit from the transaction, has a material financial interest in another party to the transaction, is a director, officer, etc. Of any other party that may derive a material financial benefit from the transaction, is the parent, child, spouse, etc. of another party who may derive a financial benefit from the transaction. And then the real kicker is otherwise directly or indirectly materially interested in the transaction. So it couldn't be possibly wider than that, but I suppose you've got a mopping up provision here in subsection E. The reality is that in any given scenario, you're probably going to be falling within one of A to D pretty clearly. B then is, I guess, intended to deal with beneficial ownership in another party, whatever that may be. Obviously, C is dealing with position as an officer or just cover off member. And then D, the more likely one, which I've seen in practice, which is the way you're a parent or spouse, etc., of the person on the other side. Again, that goes beyond where the English law stands on identifying the circumstances in which a transaction involving self-interest may arise. So that's quite a useful steer. It is, though, subject, that's subsection 2. A director is not interested in a transaction to which the company is a party in these circumstances here. So dealing with the granting of security, guarantees and indemnities. All of that then puts you in a starting position of, right, are we concerned with a transaction involving self-interest? Yes or no? These are various steps you've got to work through. You've identified the transaction. You've identified whether or not a disclosure's got to be given. And then there are some practical points that stem from that. The director is interested in the relevant transaction that's been entered into or may be entered into. And these are basically the things then that he may do as a consequence of having given his disclosure, but subject to the company's memo and arts. So I'm not sure, are you likely to see any limitations, any restrictions in a Guernsey set of articles that go to that? You could, I suppose, if they want to build it in for some kind of added safeguarding. But the position under the law, once the disclosure has been made, is that the director has pretty much free rein to continue in the normal way.
You may, in where you've got a listed company, so very widely held, typically in the UK, you may put some provisions in that. So, you know, if a director has more than 5% of the shares of that company, you may be saying, look, you can't be voting, you know, things relating to that, financial guarantees, those kinds of things. But it will be very unusual otherwise, quite the reverse. We try and make everything as flexible as possible.
Yeah. So it becomes as open as possible once the disclosure has been made.
Sure. We have some context for 1672, which is not the director's not interested in the company transaction with the third party, basically. It just seems so I don't know why it's there.
It's not as general as that, though, is it? It's dealing specifically with securities, guarantees, and indemnities. So transaction comprises only the giving by the company of securities to a third party, which has no connection with the director at the request of the third party. You could still have, bear in mind how broad the circumstances are in which a party may be deemed to have an interest in a transaction by connection to some other person in the third party vehicle. Is that what it's intended to cover off? fact that the company is giving security to that third party isn't consequential insofar as the directors.
Because it's a connection. So, yeah, which has, it's self-evident, isn't it? Why, it seems a bit out of context in the context of 167.
Oh, because, and, it's not an or, it's an and, the director is given some level of personal guarantee or indemnity or responsibility. So they, they've got an interest because they've assumed responsibility for the same debt which the company is now giving security for. So I suppose the argument would be, is the director now compelling his company to give security in lieu of the guarantee which he's given, which might do away with, which may have the effect of him avoiding liability and passing it on to the company. No, I could have explained it better. But note that, subject to all of that, it's not interested in that transaction. So it's inconsequential in any event. It's simply there to give clarity that in that scenario, he's not interested in the transaction. In fact, I'm not sure if from a policy point of view that should be the way the law is framed, but it is what it is. Because there is the scope for wrongdoing in that scenario. I suppose the safeguard is that the intention here is that the director is remaining subject to his guarantee, his indemnity, or what have you. The problem would come, and then you would fall outside the scope of this. Looking at it just as a matter of interpreting how the section is framed, would fall out of it if he then revoked his indemnity or his security.
Yeah, or if the company paid on their guarantee. So if that third party defaults on one, and then the creditors can't pay the company, and then the director says, yeah, the company paid on this guarantee, he's safe. Then that's where the conflict will arise.
Well, no, I think in that, I think that providing that he hasn't done anything to avoid his own liability. I follow your logic, but I'm just looking at what point in time do you fall out, in what circumstances rather, do you fall out of that wording, that definition?
I suppose it's security as well, actually. I don't think it's a guarantee, but if it's security, then yeah.
I think it's where the second bullet is no longer satisfied, which is that he's no longer assuming personal responsibility by way of some guarantee, indemnity, etc., which he's previously provided. As soon as he revokes that, you no longer satisfy those two bullets. And he would then have an issue. That's the evil that this is designed to protect against. But for so long as he maintains his obligations, and I think irrespective of who ends up paying, there's no self-interest, providing he's still subject to the same liability. I might be wrong, but the section doesn't look to the discharge of the relevant security of the underlying borrowing, whatever it is. It's simply concerned with the fact that he is at the same time subject to his own personal responsibility. It seems to me it's when that falls away that you have a problem for obvious reasons.
It seems like it could be abused.
In practice, would the directors typically disclose something of this nature anyway?
Probably not going to come as any surprise, is it, commercially, that the directors already secured these obligations and the company is now being asked to provide its own security. It may be academic as much as anything, you're right.
I suppose I would approach this by saying, you want to protect yourself and disclose anyway, but more importantly, this actually seems to read to more of a kind of a breach of duty issue. If you could be thinking about whether you're acting in the best interests of the company to stuff a security onto the company, which, you know, why would it be in the company's interest to give security if the director's already given a guarantee? And articulating the rationale for that in the minutes, it's almost, to me, the disclosure of the interest itself is just constrained.
Yeah.
But I suppose this probably came along because the two things what the Guernsey draftsman is concerned about is, first of all, they are very much seeking to protect the position of creditors, because we're a financial services jurisdiction. So all the way through this law, you know, security interests and creditors are protected. You know, even when a company goes into insolvency, your security is protected. That's quite unusual as a global position, but that's kind of where we come from. And I think the other theme is that when this law was coming out, was that actually, I think the committee at the time were also trying to make our companies law a little bit more user-friendly for smaller companies. You know, so if you have a, you know, you know, if you just kind of got a small businessman, it may be trying to help him a bit.
But yeah, because it wouldn't be unusual, would it, then, for the small businessman to have given his own BGs in respect of some level of borrowing, which the company may also have secured. So there's no additional burden on him for his work. Or potential risk or liability, I suppose, for not complying with the self-interest.
It's almost like the director and the company being security with the director and agreeing to give a guarantee for both delivering the same object.
The same
how
objective,
the
yeah.
interests are aligned, how to say they're conflicted, and which that provision seems to be making it abundantly clear that there is option.
But it deals with that evil that we acknowledged earlier, isn't it? Which is when the company is interposed in place of the director's security. And then the company's insolvent or whatever, and he walks away. Not that anyone would do that.
Okay.
I'm conscious of the time, so we're not going to.
Okay.
Oh, sorry. Is it just dropped?
Yeah.
It's 10 to 3, Lawrence. So it's okay. I've lost where I was. I'm conscious of the time, so we will stop shortly, but let's just finish off these provisions on self-interest before we do, because that's a neat place to stop. What if we've worked through these various steps, we've identified that a director's interested in the transaction. What are the potential outcomes here? Or 163 subsection 1. The relevant transaction may be voidable by the company. So it may be voidable at the instance of the company within 3 months of the date on which the transaction is disclosed. Unless, and then you then move on to the various carve-outs. The interest was disclosed in a proper way prior to the company entering into the transaction, or it was otherwise not required to be disclosed. So subsection A wouldn't assist the director in circumstances where the disclosure took place after the transaction had been entered into. It would only be in the case of prior disclosure. B, which is probably more likely, I would have thought here, that in practice the transaction is ratified, again in a neutral way. I would have thought as a matter of best practice that's what the director would seek to achieve, notwithstanding disclosure, but in any event looking to obtain ratification, to obtain the best degree of protection that he possibly could, or the company received fair value for the transactions. That ties in really with what we said earlier in terms of transactions that are on standard terms, or for which fair value is provided. There's no evil, so there's no need to penalise the director in any way. Subsection 2 goes on to identify what fair value is, and I'm not going to go through it now because you can sit and read it. It's a fairly a fairly straightforward work through of how the court should treat the assessment of fair value, or anyone should treat the assessment of fair value. What factors regard should be had to. No,
I think it's just the first. Are you thinking the same way?
No, I'm just really curious.
Well, it says a transaction is voidable anytime 3 months after the date of disclosure, unless it was disclosed at the board meeting. That to me is completely unnecessary then, because it's been disclosed already.
disclosed to the board in accordance with FLIRT
Yeah.
prior to the company entering into the
Exactly.
transaction.
This one talks about after the date the transaction is disclosed. So why would we need to look at what was done before the transaction was? Sorry.
Because the disclosure itself may have taken place after the date on which the transaction was entered into. And so your 3 months runs from that date of disclosure, not from the date of the transaction. So if
Yeah.
the date of disclosure comes later, after the transaction's been entered into, if it's a month later or a year later or 3 years later, it doesn't matter because the company has still got its 3-month period to deem the transaction void. At least that was my reading, but I'm open to
Unless the
correction.
director's interest was disclosed prior to the company entering. Anyway, I think I'll just read it with a fresh mind. I'm sure it's
So I'm looking for any influence. Was that something?
Hardening provision,
Running periods.
a hardening period.
Yeah. That's my disclosure. Use that term is different.
Yeah, normally when we're talking about hardening periods, that's in the context of taking security. I think what this is trying to say is that there's a difference in time. You know, the disclosure has to take place so that it's, you know, before the director in question enters into debate, so that everybody knows his position and his conflict, and he can't necessarily influence, or he can even actually recuse himself from the decision, subject to what Gavin has been said before about the dangers of doing that. But if it comes to light, if the transaction then proceeds, then at any time thereafter, it can come to light that this took place and the board, you know, didn't have all the relevant facts, which is the key to directors' duties. So I think it's seeking to find a way of addressing that mischief. Although as a lawyer, it scares the pants out of us as corporate lawyers, because we don't want any we hated this when it came to law, because we don't want any transaction that can be made voidable or is voidable, and therefore our legal opinions are qualified. So this is why this is just so important as to a corporate lawyer, because you do not want a transaction which, you know, can be made void.
Yeah. And that's the point on the final slide and all this that I'll come on to in a moment. Just as a point while it occurs to me, 163 subsection 2, I said it deals with fair value and how you determine fair value and what time. I'm not going to go through the detail. But it puts the burden of proof, in effect, on the company. It's for the company to prove that it did not receive fair value, as opposed to putting the burden on the director to prove that the company did receive fair value. The burden under that section, 163 section 2, is a negative burden that's imposed on the company to prove it did not receive fair value. Following on from Fran's kind of train of thought then, you don't want to be finding yourself in a position where a transaction is possibly voidable, not least because of the potential impact it may have on any other parties who are interested in that transaction. And certainly that's something that the courts hate to be faced with, because they do not want to be in a position where they're having to unpick something which has gone before. Subsection 3 then again confirms that in the event that a transaction is avoided, or if it's not avoided, then the liabilities of the director remain. Again, at all times, we've seen this in various ways. It doesn't matter that some steps may be taken to preserve a transaction. The director still remains subject to his liabilities. In section 164, this is probably looking then in more practical terms as what is the likely outcome in these scenarios. The avoidance of a transaction does not affect the right, title or interest of a person in any property which is acquired in good faith, valuable consideration, without knowledge of the director's failure to disclose his interest. So if you then follow some transaction down the chain, down the line, what happens next? Director enters into a transaction, he acquires some property. He then goes on to sell that property. Suppose that might be one reason. What happens to the third party in that situation when the company decides to void the initial transaction? The effect of 164 then is to protect the position of the third party, providing he entered into his transaction in good faith for consideration and without knowledge. Then, insofar as he's concerned, he has no further interest in any proceedings, and it simply again becomes an internal issue as between company and director to pursue company's losses in the usual way. Yeah, for all intent and purpose, that's again not something I've ever seen operative in practice, because the court just would have no real interest, I don't think, in following that chain through. Their focus will simply be on, well, look, if the company suffered loss, we deal with it internally. It's as simple as that, rather than trying to undo chains of transaction. So it's worth you reviewing in your own time the provisions dealing with self-interest, because they are quite involved, and Guernsey law goes beyond what the provisions are in the English and the Jersey law. So it's worth you working through those and just making sure you've got clear in your head the way they all kind of come together. It isn't the case that you can just be content with, for example, 162 and the basic disclosure requirement. You've got to follow it through. 162, 163, 164, through to 167, I think, ultimately, because all of that together gives you the position in law and identifying whether or not there's a disclosable transaction, whether or not the director is involved in a transaction of self-interest, what he needs to do, and ultimately what the outcome may be as far as the company is concerned. It all needs to come together. But it gives you a fairly straightforward framework to work through the law on a set of given facts and advise the company or the director what are their rights or what are their liabilities. That leaves a kind of final couple of slides. It won't take too long to go through, but let's stop now. I'm conscious of the time. Let's stop now and have a break for 10 minutes. And then we'll pick up and finish off on director's duties and look to minority protection. Unless you've got any other queries. Yeah, okay, good.